I'm Akash Chandran, the Legal Advocacy and Communications Manager at the Asia Justice Coalition. Amongst other things, I manage the Crimes Against Humanity file at the AJC. Thank you so much for joining us today for the workshop on Crimes Against Humanity Convention, Vision and Strategy for ASEAN. The Asia Justice Coalition, Amnesty International, ALTSEAN-Burma, and the Rohingya Maìyafuìnor Collaborative Network are convening this online workshop in conjunction with the ASEAN Civil Society Conference, ASEAN's People's Forum 2025, held annually in parallel with the ASEAN Summit. ACSC APF is the largest and most inclusive civil society gathering of organizations in Southeast Asia, organized by the civil society in the country that holds ASEAN chairmanship. This year, ASEAN chair is held by Malaysia, and therefore the APF, the ASEAN's People's Forum, will be held in Kuala Lumpur, Malaysia on 14th and 15th of October in person. For some context of the workshop, in December 2024, after years of deliberation, the United Nations General Assembly decided by consensus to move the International Law Commission's draft articles on crimes against humanity to formal diplomatic negotiations to adopt a binding and a global convention on the prevention and punishment on crimes against humanity by the year 2029. The formal preparation of the negotiations will begin early next year, January of 2026, with the first preparatory committee, or PrepCom. In this background, this workshop aimed to raise awareness, inform the audience, especially in Asia, about the draft articles on crimes against humanity, the ongoing processes and deliberations at the UN, by contextualizing the relevance of such a future convention for ASEAN member states by looking at the two situations of Myanmar and the Philippines. We have, over the years, unfortunately, witnessed less participation from ASEAN member states as well as ASEAN CSOs. According to us, it is important to center Asian, including ASEAN civil society organizations, victims and survivor groups, in a treaty-making process for a treaty which will be global in nature. This workshop, therefore, will be interactive and participatory in nature, where we will have presentations by the speakers, followed by open discussion on a curated set of questions. So we will urge you to participate, ask questions, and share your reflections with us. Before doing that, some housekeeping rules. First, this event is being recorded and will be disseminated on the ACSC APF website as well as social media pages. So please feel free to leave the meeting or keep your camera off if you're not comfortable with the event being recorded and your presence being marked. The second, the workshop will be held in English. No live translations will be provided, unfortunately. However, you can enable the auto caption on Zoom should that help you. Third, to reiterate, if you have any security risk or concerns, please use the Q&A or the chat box to send in your questions. Alternatively, if you wish to take the floor, you can keep the camera off and use a pseudonym to identify yourself. And lastly, for the duration of the workshop, please ensure you're on mute and use the raise hand feature on the Zoom should you decide to take the floor to make an intervention. With that, I'm happy to pass on the floor to Dr. Priya Pillai, the Executive Director of the Asia Justice Coalition. To start the first segment, Priya will take us through the available tools that we have in international justice and accountability and allow us to locate the future convention on crimes against humanity within it. Just as a reminder, please feel free to put in your questions in the chat and we will get to them after the first two presentations. Thank you. Over to you, Priya.
Thank you, Akash, and for your very sort of able moderation and for pulling this together. So just to say good morning, good afternoon, good evening to all of you. I'm really pleased that we have a great number of participants to join us for this important discussion. This is really a critical time, regionally as well as globally. So again, just very happy to have you here, and we're looking forward to an interactive and engaged discussion. So as you all know, we are now faced with protracted conflicts across the world, systemic and massive human rights violations. And I think it's really, there's a need for greater global momentum, and there's a need for greater international solidarity against rising impunity. And this includes countries like Myanmar, Sudan, Ukraine, Palestine, Afghanistan, to name just a few. Many of the mass atrocity crimes that are committed today may in fact be classified as crimes against humanity, a core international crime. But unfortunately, in international law today, there's a legal gap in regard to the prohibition of crimes against humanity, crimes that are widespread or systematic, that are committed against a civilian population in times of conflict or peacetime with knowledge of the attack. Various acts could fall within this category, including murder, enforced disappearances, extermination, persecution, torture, rape, and other crimes. Let's turn and draw comparison to other international crimes and see where crimes against humanity sort of are located in that context. The status of other international crimes, such as the crime of genocide, has been the subject of an international treaty, as you all know, the Genocide Convention of 1948, as have violations of the laws of war or international humanitarian law, the Geneva Conventions of 1949, and the additional protocols of 1977, as well as customary international law. There's, however, no standalone treaty in relation to crimes against humanity that would establish state responsibility for such international crimes. The importance and relevance of a crimes against humanity treaty is fundamentally to fill a gap that still exists to this day in the legal architecture in relation to the obligation to prevent and punish the occurrence of these specific mass atrocity crimes. There is, of course, one multilateral treaty that does in fact address crimes against humanity, but only for the specific purpose of holding individuals criminally responsible before an international court. And this is, of course, the Rome Statute that establishes the ICC in The Hague. As I said, this is a very specific treaty negotiated in order to establish an international court that has jurisdiction to prosecute these crimes in specific instances, usually when a state is unwilling or unable to prosecute these offenses itself, and based on whether a state has consented to the jurisdiction of this court by ratifying the statute. This is different, for instance, from the Genocide Convention, which is a treaty that establishes the responsibility of states to undertake particular actions and is not about the responsibility of an individual. In a similar vein, a treaty on crimes against humanity would be a step towards state responsibility for these mass atrocity crimes. Now, let me turn and dispel a few misconceptions, because I think there is quite a lot of confusion as well in regard to what's happening on this treaty process, and the link also potentially to the Rome Statute. The Rome Statute has a provision on crimes against humanity, but I think the misconception is that this is sufficient and that there is no need to elaborate on a treaty on this matter. To the contrary, as the International Law Commission, which is really the architect of these draft articles, has elaborated in great detail in a commentary in its draft articles, there are multiple obligations that include that of prevention of such crimes, of international and state-to-state cooperation in legal assistance, extradition, prosecution, rights of victims, among many other areas that are encapsulated in this draft treaty that are essential to address the commission of these types of crimes. The other elephant in the room that I will address is the wholly unfounded fear that seems to be that the elaboration of such a treaty on crimes against humanity essentially means that states would be agreeing to the Rome Statute through the back door. This is incorrect and is a misunderstanding of the essentials of treaty law as well as of the Rome Statute. Agreeing to a treaty on crimes against humanity for those states that are not party to the Rome Statute does not mean they have automatically adherence to the Rome Statute. At the end of the day, adherence to treaty provision is still dependent on ratification of the treaty or the application of jurisdiction. The idea of the draft, these are the ILC draft articles, which borrows the definition of crimes against humanity from the Rome Statute, is that it is a starting point for multilateral negotiations, which could finesse the definition based on the evolution of international law developments in these past years. So to have a robust and strong definition still. The other multilateral treaty that I will mention is the Ljubljana, The Hague Convention on Mutual Legal Assistance for International Crimes, which was negotiated in 2023, where the Asia Justice Coalition and our other partners as well in the room took an active part, and that this is a complementary instrument. The CAH Treaty, the Crimes Against Humanity Treaty, and the Mutual Legal Assistance Treaty are not antithetical to each other, but rather could be mutually reinforcing tools to combat impunity. Both aim to address atrocity crimes and provide a detailed framework with which to do so. And really one of the key aspects of these is state cooperation and how is it that states can work together in the prevention and punishment of such crimes. Let me now turn very briefly to the regional perspective and why it's important for this region. Essentially, this treaty would fill an important gap that is felt particularly in our region. There's an overwhelming lack of a conducive legal infrastructure for international crimes in the Asia Pacific. This could be the lack of domestication of international crimes, non-signatory status regarding international crime treaties. Furthermore, in this region, there are no supranational legal institutions, such as regional courts that are present in Europe, in the Americas, in Africa. There's also a low uptake in domestic law regarding the criminalization of international mass atrocity crimes. However, our jurisdictions have engaged in international criminal accountability, even if to a limited extent. This is to say that there is a precedent and there are examples that we have. Asia has been the site of war crimes trials post the Second World War, the International Military Tribunal for the Far East, as well as domestic trials. It has been the site of hybrid tribunals, including the extraordinary chambers of the courts of Cambodia and the Special Panel for Serious Crimes in Timor-Leste, as well as domestic mechanisms for international crimes, including the ICT in Bangladesh. Now, none of these are without their problems, but the notion that international accountability is alien or cannot take place in the Asia Pacific, I think, is one that needs to be debunked. It's also worth noting that in many countries in our region, there are no domestic law provisions that would encompass the notion of crimes against humanity or mass atrocity crimes. Encapsulating these provisions in domestic law, drawing from an international treaty, would fill a key gap in atrocity prevention. Turning to ASEAN specifically, and for ASEAN countries and civil society in the region, I think it's particularly important to support this new treaty and to engage actively in the discussions and negotiations that will commence soon. Taking a leaf from recent discussions in the region, I would point in particular to the fulfillment of Strategic Goal 9 of the ASEAN Political Security Community Strategic Plan that forms part of ASEAN 2045, our shared future. Specifically, the goal is an inclusive and cohesive community that respects political, social, religious, cultural, ethnic diversities, which upholds the principles of democracy, rule of law, and good governance, and respects fundamental freedoms, promotes and protects human rights, and promotes social justice. To achieve this goal, active engagement of civil society and stakeholders from the region in the CAH treaty process is crucial. We are at a historic juncture, one where we have the opportunity to ensure that such crimes can be redressed in international and domestic law. It is time to ensure a robust treaty on crimes against humanity, as well as the possibility of greater justice and accountability in and for our region. Thank you very much for your attention.
Thanks, Priya, for that helpful remarks and kicking us off. While we are witnessing a direct assault on international legal frameworks and institutions, I think it's important to remind ourselves the value of fighting impunity and holding perpetrators of crimes responsible. Also, just on Crimes Against Humanity Convention and what it offers, when adopted, it will empower states to exercise their national jurisdictions over the alleged perpetrators and, kick off an ownership of national jurisdiction in that sense. So thank you. And with that, continuing our conversation on the draft articles, we have Jan Wetzel, Senior Policy Advisor at Amnesty International Regional Office in Bangkok. Jan will highlight the structure of the draft articles, give us an update on the process at the UN and the status of draft articles as of now. Over to you, Jan.
Thank you, Akash. Also, thank you to the Asia Justice Coalition for setting this up, and thank you all for joining us today. As Priya said, it's really important that these discussions are sort of taken out of the technical bubble and are put on a much broader grounding, geographically broader, especially with regard to civil society and their victims and survivors organizations, but broader generally, that we have more discussions on this. As said, so this process got kicked off formally in November, December last year with UN resolutions, and will formally start in January 2026. So we're slightly in between these, in the limbo phase, in between. But the first thing I would like to point out is that this convention has been in the making for over a decade. So not just the ILC, but university groups, international lawyers have been discussing the possibility and how to fill this gap that Priya pointed out for more than a decade. So there's a lot of work that has already gone in there. And that culminated in the so-called draft articles on the crimes against humanity by the UN's International Law Commission that were adopted in 2019 already. Then nothing really happened. And then the full-scale invasion of Ukraine by Russia in 2022 happened. And in the fall of 2022, the states decided, oh, we really need to do more on this. We need to reawaken this process. And this led to 2 further years of negotiations or discussions at the UN, and finally to this resolution. The second point I would like to make is there are lots of elements in terms of consensus here, where states, at least almost all states, agree. So the first point really was that there is this gap that Priya pointed out. Nobody doubts that there is this gap. The other international crimes, most of them have specialized treaties. Crimes against humanity doesn't, and the ICC can do its part, but can't do everything. So there was an almost consensus in terms of to move to these negotiations. And of course, the resolutions were adopted by consensus, with a couple of countries disassociating themselves, but formally it's consensus. There was consensus that these draft articles should be moved to formal negotiations, and that there is a need to fill that gap. Now, the draft resolution already was co-sponsored by 99 countries. That's more than half of the UN. So it's not consensus technically, but it's a majority. In terms of co-sponsorship at the UN, that's a very large number. So there was really widespread support for this convention project and to move this forward. Unfortunately, less so in Asia, and specifically by ASEAN countries, to which Akash, I believe, will speak more later. But there is a gap that needs to be filled, especially when it comes to mass human rights violations outside of the context of armed conflict. For example, Priya mentioned many conflicts, but let's just say Venezuela is another example where we don't have an armed conflict, but we have widespread or systematic human rights violations against a civilian population. So there are these situations, we will hear about 2 of these today, in the Philippines and in Myanmar, but there are obviously many more globally. Now there's a little bit less consensus in how to fill that gap. But here, this convention is, we believe, a fantastic opportunity. And the work that already has gone into this is a solid basis on which to start negotiations. These draft articles have been discussed broadly and widely. And again, while they're not perfect from at least Amnesty's point of view, they do form a solid basis that could go into an eventual convention. Amnesty International has already put forward recommendations in 2023, and will put forward recommendations soon, next month, with regard to the process. We do encourage other civil society organizations to do the same. But the bottom line remains that the draft articles as they are a very good basis on which to start the negotiations, and they essentially need to be refined, but their core principles also need to be retained. One more point here in terms of support. East Timor, not technically an ASEAN member state yet, but obviously a voice at ASEAN, was the only country in the ASEAN group, let's say, that co-sponsored the draft resolution and has also come out publicly in favor of this convention project. They joined a statement of 8 Portuguese-speaking countries that were all strongly in support of both the process going to negotiations, but also the ILC draft articles being a solid base for this process. Now we are in this limbo, as we said. The next step will be January 2026, when there will be a preparatory committee and a working group meeting in New York. And the first decision that they will make is what kind of civil society organizations can actually take part in these, in the diplomatic conference, meaning they can be in the room, potentially they can speak, they can hand in papers, they can receive papers, they can make oral interventions, they can partake in mini discussions. All of these are things that in the past has happened with international treaty negotiations, such as the Ljubljana one that Priya just mentioned. Now, this was a contentious issue at the United Nations last fall. At the UN, civil society organizations with what is called an ECOSOC accredited status at the Economic and Social Council, they are allowed to go into the UN, they're allowed to get a pass and at least sit there and sometimes speak. And those will be allowed at the diplomatic conference for the Crimes Against Humanity Convention. Now, but what about organizations that do not have this status? This status sometimes is difficult to get. It's a very long process, and it effectively excludes a lot of small organizations, organizations with less resources, less staff, newer organizations of victims and survivors, which is why the Asia Justice Coalition, Amnesty International, and others are strongly calling that in January 2026, a decision must be made to have civil society participation as broadly as possible, not just those with formal UN observer status, but all others who apply, that they can go as well. There should be no artificial barriers to civil society discussing this, or being part of the discussions, and not just passively listening or dialing in on camera, but actually, if they can do it, be in the room, advocate for their goals. The second stage, or the second milestone after this would be in April 2026, when there is a deadline for states to submit written submissions to the draft articles. Now, the draft articles themselves, they will not change. So there will not be a revised draft articles. This is a concluded process. But states now have the opportunity to put in writing what they don't like about the draft articles and what they would like to change when the draft articles are worked into an actual convention text. And this is where, again, civil society organizations can participate to either directly making submissions at Amnesty International, for example, will, or of course, you do advocacy with your states. You already do advocacy with your home states. Try to find out what they are, if they are planning anything, what they are planning, what are their priorities, which parts do they not like, Civil society can already do this now, and we should try to influence states' positions and what they send in writing by April 2026 as much as we can. That will not be the final word, of course. The negotiations will be actually or formally in 2027, 2028 and 2029, potentially even a year after. So we are still talking years until we hopefully get to a final text. But in the moment, the January and April 2026 deadlines are really something that all of us should be aware of and work towards. And then maybe I just need to check how much time I still have. Just a few points where Amnesty believes, for example, the present draft articles have a very good base. It's specifically when it comes, or especially when it comes to the principle of universal jurisdiction, the fact that states that have a alleged perpetrator, a suspect, and we should keep in mind at that moment it's a suspect and the presumption of innocence applies, but the states need to investigate. The state on whose territory this person is found needs to investigate. If there is sufficient admissible evidence, they need to arrest, and then they either need to prosecute or extradite. That's a core element of this new convention, that states, member states, either they extradite to another state for purposes of prosecution, or they prosecute themselves. But that is really the one core point. They can do it themselves. It's not an international organization like the ICC. It's not some outside foreign power that is interfering. It is the state itself that can and then must do it. Final point on one thing where we do think some cautious developments are still possible, and this is just one example of many, is the element of gender justice. As Priya said, the present catalog of crimes against humanity is more or less copy-pasted from the Rome Statute of 1989. Now, in the past 27 years, the world and international law has moved further, especially when it comes to recognition of gender-related violence, sexual-based violence. And these developments, we believe, should be reflected in the new convention when it comes. That is really an opportunity to put international law firmly in the modern sphere. I'll stop here. Thank you.
Thanks, Jan, for covering the decade-long process and summarizing it for us in last 10 minutes. And thank you for also explaining as to what's the next steps for civil society as we move forward with the timeline that we have until 2029. I think I would also like to highlight the role of individuals, especially like that of Professor Leela Siddharth, who has been at the forefront of leading the Crimes Against Humanity convention with her Crimes Against Humanity initiative, which began in 2008 and 2009. So this is for those who argue that this is a new concept and a new proposition. The lack of a concerted, specialized treaty for crimes against humanity was earmarked since the Rome Statute and has been in the works. So it has been decades of work that has been put behind this, and we are glad that we are moving forward with a deadline of 2029 to have a global and binding treaty. With the end of the first two presentations, we are moving to the first discussion question, which is why addressing impunity is important for ASEAN. And we will put that question on the chat as well for you to reflect and share with us. So please feel free to raise your hands or share your comment, share reflections on the comments. The answer to this question might seem obvious, but we often hear that the Crimes Against Humanity Convention is not relevant for Asia as a region. And this is largely, quote unquote, Eurocentric and neocolonization sort of project that is being imposed on Asia. So with what Priya had initially said, what we are also trying to send through such webinars and workshops is that messaging that it is relevant for Asia as well. So if you could share your reflections on the question as to how addressing impunity would also align with ASEAN principles or policy, we would welcome your thoughts. As I give you a moment to think about this question, perhaps I would also go to Priya once again. Priya, if you could just, following your remarks, if you could reflect on the engagement of Asian states that we have seen in regards to other international legal frameworks. Do you see that Crimes Against Humanity offers a broader and easy inroads for states, as it's a horizontal convention, much like Genocide Convention, and do you think that will be more palatable for Asian states going forward?
Thanks, Akash. And of course, not to preempt your presentation. So for everybody to know, the expert on Asian states' position in this room is Akash. So he will actually walk you through positions on CH. But I think maybe just the sort of discussion around Asian states and their perspectives on, say, international justice and accountability, and sort of what the broad approach has been. And again, not to lump all Asian states together. Again, this is a very big region. There are differences of approach, there are differences of opinion in how states approach this. But what I will say is, I think the hesitation around, say, the ICC, which was about individual criminal responsibility, will obviously be less here, because you're still at this point talking about horizontal engagement. You're talking about a state signing up to a treaty, of course, placing obligations on itself, obligations to prevent, obligations to punish. But the point is also that there's a lot of control and there's a lot within the remit of the state. So, one approach would be, well, crimes against humanity are in any case peremptory norms of general international law. They're jus cogens. It actually would be better to have a treaty that formulates and specifies how states engage with each other and how they cooperate on these issues, rather than have, have misconceptions or a lack of clarity around that, which then again would prevent states from stepping up and ensuring prevention or working towards atrocity prevention as well. I think the other thing that I would just point out, just from a geopolitical perspective, is the Asia Pacific is the region with the largest population. It's 60% of the world's population is here. And what does it say about this region if we do not have states and civil society pushing for, a norm, a jus cogens norm like this, which is a core international crime, that really we should all be invested in ensuring that these do not occur, in ensuring that there's no impunity for these, and that there's sort of no safe haven within this region for potential perpetrators of such crimes. So I think for the region specifically, there are a lot of discussions around Asian values, around neocolonialism, but I think it's also time to step into this new era to say that we are seeing commission of mass atrocity crimes around us, and we need to look at strengthening the legal architecture as well, which in this region is quite weak. And this is a key component and a key way that we can do this. So I think there's a very broad-based argument for this region specifically as well, that we need more robust mechanisms and frameworks. And this is one such framework that we need to get behind.
Thanks, John. Do you have any reflections on the same question? And while you do that, could I also ask if you could share with the audience about the proposals that we are seeing for the amended text of the draft articles, so as to widening? You have already mentioned in regards to the gender justice, but we do have arguments or proposals for slave trade and slavery as well. So if you could also just touch base on that.
Yes, thank you. So first on the specific question of the regional value, maybe just 3 small points. One argument we often hear, especially out of Asian states, is that they want their state sovereignty protected. Now we know sovereignty should really not be a shield against accountability. It should not be used for impunity. But it's, you know, it is recognized. It's a core value in international law, obviously, and it's a very high interest for many Asian states. Now here there are many provisions in the draft text that I would actually call sovereignty saving. One is, for example, I already mentioned this duty to either prosecute or extradite, but you have to do this. Now, if there are multiple states involved, let's say, you know, the atrocities took place in state A, the perpetrator is from state B, was arrested in state C. There's a system of notices and consultations that the various states need to conduct with each other in terms to figure out, so who's actually best placed to do these, to actually then carry out a potential prosecution. So a state that says, well, you just arrested my national, but I want to do this, they can enter into consultations. There's a system, a mechanism planned in the convention. If states can't agree how this, at the very larger scale, if there's the states cannot agree how to implement this particular convention, they could even go to the International Court of Justice. So there are mechanisms in there where states can complain, where states can talk to each other, states must consult each other. So these are all situations where state sovereignty is safeguarded. Secondly, this convention would really give a toolbox to states to do these prosecutions. One element, and that is really different from, for example, the ICC statute, is really that there are rules on state-to-state cooperation. The Ljubljana Convention has that, but the ICC statute does not have that. And the advantage here would be that there would be a common framework, a common rule book on how to cooperate. States would have to set up units so that they can talk to each other, that they can get in touch and liaise with each other, or how to hand over evidence, how to seize assets. All these elements of cooperation could be covered under this toolbox. And thirdly, again, on a slightly more abstract level, if you look at the almost 100 states that co-signed this, most of these, because that's the nature of it, are small and medium-sized countries. Because small and medium-sized countries know that we need a rule-based order to actually have, or they need a rule-based order to have their own rights protected. I have just been to a conference in Singapore a couple of weeks ago where members of the Singaporean delegations emphasize this in that regard with to trade and environment, but still the rules are the same. Small and medium-sized countries need a rule-based order to safeguard their rights, their sovereign rights, versus the very, very big players, because this isn't a jungle. This shouldn't be, might makes right. And if a state really has an interest in creating a rule-based order, this is one element where this can be done. Now, just quickly, I think there are more and more questions, so I don't want to take up the floor too much. But first question was on the potential inclusion of reproductive violence, sexual coercion as a component in the definition of gender-based violence within crimes against humanity. Yes, so there are quite a few suggestions when it comes to gender-based violence. One is, and that's actually what Amnesty and others have made, to add any form of violation of reproductive autonomy to the catalog of crimes. So this is not, what you quite often see in terms of rape or other types of direct violence. This could also be forced childbearing, forced nursing, forced taking care of children. these are elements of reproductive autonomy that needs to be safeguarded. Forced marriage, which is at the ICC already a recognized crime against humanity, is now being proposed, including by Amnesty International and others, to add explicitly to the catalog of gender-based crimes in the catalog here. And there are many more points where the negotiations give a window, an opening, an opportunity to advocate for these elements. To what extent they will be, we will be successful in advocating for this is a different question, but it's certainly an opportunity, for example, to raise the issue of gender apartheid, of gender persecution separately from other types of persecution, to raise the awareness of these types of crimes, and hopefully get them into the convention at the end. Let me just see. Okay, I'll stop here, but Akash, please come back if you see a question for me. Thank you.
Thanks, Jan. Priya, I think maybe I'll come to you. There's a question from Chuka Arunse Onyala about the first being, has the absence of specialized treaty affected the prosecution of crimes against humanity, either in ASEAN or elsewhere? And I think I'll club that with the second one, that is, does this new treaty have specific provision that will predictably increase ability of states to prosecute crimes against humanity, especially given that CAH is already presently prosecutable under universal jurisdiction? So I think we have those two questions for you for now.
Thanks, Akash. I think I'll club some of my responses as well. I mean, there was a third question also, and I think the answer is implicit in a few facts. One is that, as I had mentioned before, we don't actually, in Asia Pacific, there is really a dearth of domestic implementation of international mass atrocity crimes. So, for example, it would be very hard to find an actual clear definition of crimes against humanity in a domestic criminal code that would then enable that to be prosecuted domestically. So I think the frame of reference really has to be the legal framework in the region as well, and in the domestic law of the region. And what this would help basically do is ensure that states sign up, say, yes, we recognize we are obligated to then incorporate and make sure that this is within our domestic law. That's one, so that you would have the ability to prosecute perpetrators or suspects within your domestic legal framework. And I think that actually answers the third question, which is, are there safeguards that this would not just be global north finding a way to prosecute citizens of the global south? Well, if you have your domestic framework in place, essentially to Jan's point, extradite or prosecute. So you have the ability then, and you have the wherewithal, the legal framework to actually move ahead with the prosecution. And if not, then the Crimes Against Humanity Treaty, I think draft Article 14 has this very detailed encapsulation of what it means to cooperate. How does that cooperation happen? And then that would mean then that you extradite, a suspect to another state to enable that prosecution. So a lot of it is these horizontal obligations, which are between states, which leaves a lot for states to actually plan and ensure that their domestic jurisdictions are up to speed as well. So I think that would answer, some of the concerns that have been raised and flagged.
Thanks, Priya. We have another question from Michelle. Michelle, good to see you. Would you like to take the floor, or should I read the question on your behalf?
I think you can go ahead. Thank you so much, though, for the generosity.
Thanks, Michelle. Michelle is asking that would framing the messaging based on how the Genocide Convention has been effective in the case of Myanmar and Palestine, and several countries in ASEAN have been parties, and CAH would be a step in being more comprehensive in combating and preventing atrocity crimes in general. The Genocide Convention may be a good analogy to remind ASEAN that these conventions are not new and have been worked with by global South countries. So Jan or Priya, whoever wants to take this.
Thanks, Jan. I'll go ahead. I mean, Michelle, yes, agree with you completely that this is an additional step, but it's it's very specific to this one core international crime, which we have only in the Rome Statute. I mean, it is also surprising that in the last 50 years, we've seen a movement on the Genocide Convention and articulating these norms in a legally binding treaty. We have the IHL conventions, we've got the Geneva Conventions, but it's taken this long. And I think the point you make is very good, that yes, this is an analogy to remember that actually in the discussion around the Genocide Convention, a lot of global South states, including in the UDHR, were actually key proponents and formulated the language as well. So again, this is not something alien that's being imposed. It's really something that global South countries have been part of these discussions and helped articulate these norms. So I think it really is way past time for this treaty to find wider support within this region as well, and ensure that we have clarity of these legal norms now and responsibility for prevention as well. It's not just for punishment, but it's also for that atrocity prevention angle that I think it's really important. So thank you for your comment.
Akash, if I just add one point, both in response to Michelle, thank you, but also Chuka earlier on. In terms of, yes, in principle, these types of crimes already fall under universal jurisdiction at the moment. However, many states do not take this opportunity. And where they do, we have a patchwork. We have a patchwork of national norms. Now, this treaty would give not an identical, but a harmonized framework for states to implement this on the national basis. Therefore, all states know the rules. It's a common rule book. They all are under the same obligations, how to do this, what to do, and when. I do think that would dramatically increase the chances of prosecutions, not just because the more states sign up, the more territory there is where a suspected perpetrator can be arrested when they travel, but also because states feel they know the rules, they know what they're doing, they have trust because they know the other side is playing to the same rules. It's not just a patchwork of rules, and that that also I think goes partially into towards responding to Michelle's question. I think there's an interesting element, at least to be considered, with apologies for those of you in the audience who are not familiar with the legal frameworks. So there is the Genocide Convention. This is presently, obviously, being adjudicated in international courts with regard, for example, to Myanmar. But those of us who work on this know it's incredibly difficult to actually prove. There's a very high threshold, as it should be. There should be a very high threshold to be able to say a particular set of human rights atrocities meets genocide. One could make an argument that at least some of these situations could be prosecuted under a crimes against humanity framework, because that at least means that the perpetrator will face justice and potentially go to prison. We should not have impunity because it's too difficult to meet a particular legal standard. And some situations where just factually or in terms of intent, it's very difficult to show that genocide took place. Crimes against humanity would be a very good option to show that there is a systematic, widespread attack in terms of human rights violations. It's a very high level, and it's also a very high threshold, but it would actually, I believe, enable more of these prosecutions because it's not quite as difficult as it is for genocide. Thanks.
Thanks, Jan. And I'm seeing a few more questions on the chat. We'll be taking it in the second section. But for now, we'll be moving on to the second section of the workshop. That is building on the previous conversations. We'll now focus on two country situations, Myanmar and the Philippines, and that have faced and continue to face crimes against humanity being committed against their civilians. First, we'll go to Yasmin Ullah, the Executive Director of the Rohingya Maìyafuìnor Collaborative Network, who will speak about the situation in Myanmar and that of the Rohingya. Yasmin, floor yours. Did we lose Yasmin for a minute? It seems like. So I think we'll give Yasmin a minute to connect back. But for the time being, we'll then go to Rachel Chu Howard, who is Southeast Asia researcher with Amnesty International, who will be talking to us about the Philippines and the situation therein. We have, in the past few months, seen traumatic, range of events, with the former President Duterte being transferred to The Hague and proceedings against him being initiated for crimes against humanity as well. Rachel will share with us her, read of the land and what's the sentiment looking like on the ground as well. Rachel, over to you.
Thank you, Akash. Hopefully Yasmin can connect soon, but happy to go ahead and talk about the Philippines. I thought I would divide my remarks today into two parts. First of all, to talk about the current situation in the Philippines and also recent history, the crimes against humanity committed in the context of the war on drugs, just for those who may be less familiar with the country or need a refresher. And then I would like to talk about the potential value of a Crimes Against Humanity Convention for the Philippines. Firstly, really a recap of what we saw, some of the darkest moments in ASEAN's recent history, apart from, of course, the ongoing crisis in Myanmar. Many of us will have watched in horror as in 2016, former President Duterte launched a very violent and murderous campaign against drugs in the Philippines. Thousands of people, the vast majority from poor and marginalized communities, were killed by the police or by people with links to them, people believed to have links to them, for allegedly using or selling drugs. And this was new for the Philippines at large, but not for Duterte. He had waged a very similar campaign over decades while he was mayor of Davao City and as the alleged founder of the Davao Death Squad. During Duterte's presidency, we saw how police targeted unverified lists of people, stormed into their homes and shot dead unarmed people, including those who posed no risk or did not resist arrest. And in many cases, the police also planted drugs and weapons they later claimed as evidence. And this was driven by orders and pressures from the top, including financial incentives. There's evidence that there were payments to police or hired assassins per kill, as well as police stealing from victims, also participating in funeral home rackets. So in so doing, police actually engaged in an informal economy of murder. And what Amnesty International's in-depth investigations and other investigations carried out by human rights groups concluded was that the widespread systematic violations, including the extrajudicial executions committed in the war on drugs, amounted to crimes against humanity. As you mentioned, Akash, in March 2025, almost 2 years after Duterte left power and nearly a decade in the fight for justice and accountability, Duterte was arrested by the government of the Philippines under a warrant issued by the ICC, and he was transferred to The Hague to stand trial for the crime against humanity of murder. And although Duterte's arrest was a monumental step, much more remains to be done to ensure truth, justice, and reparations for survivors and victims. And unfortunately, apart from the arrest of Duterte, there remains almost no other forms of accountability for those responsible for suspected crimes. This applies to both the government and law enforcement agencies. So justice and reparations for the families of victims remains almost completely lacking. And actually, although they have dramatically reduced under the Marcos government, drug-related killings do continue to be reported. The current administration has also failed to credibly investigate, let alone prosecute, those of committing and ordering extrajudicial executions, despite their promises. So Amnesty continues to call on the government to carry out these thorough, independent, effective investigations, where investigations uncover admissible evidence, sufficient evidence of criminal responsibility. We continue to call for the government to ensure genuine criminal prosecutions. This would, we believe, complement the ongoing investigation and Duterte's trial that continues at the ICC. So what is the potential value of a Crimes Against Humanity Convention for the Philippines? Firstly, it really could help strengthen the accountability for systematic violations, such as those we saw in the war on drugs. You will note that the war on drugs did not take place in a conflict situation. Crimes were committed in peacetime, and therefore the laws of war did not and could not apply. A Crimes Against Humanity Convention would make it clearer by obligating states to prevent and punish crimes in any context, regardless of whether they occur in peacetime or wartime. Secondly, it would support victims and survivors, something that has been severely lacking for victims, families of victims and survivors of the war on drugs. The convention would ensure that there was stronger measures for victim protection, reparations, and access to justice. It could create stronger frameworks for witness protection, currently extremely weak in the Philippines, and crucial in cases involving state actors or powerful groups. It would ensure that victims are recognized not as collateral, but as rights holders. Third, public officials, military, police might think twice before engaging in abuses in the future. It would signal a really strong political commitment to human rights, which could deter future leaders from using state machinery to commit grave violations. And yeah, as has been mentioned, it would complement the ICC investigation, not conflict with it. It would allow more people to be held to account in the Philippines. I think we all know that the ICC, at the best, will only be able to prosecute a handful of perpetrators, if that. We're lucky if people end up at the ICC. In principle, states would be able to process a higher number of alleged violators. There would also be no argument of foreign interference, as there is at the moment regarding the arrest of Duterte and his transfer to The Hague. And it's also worth noting that the Philippines left the ICC under Duterte. This wouldn't be a concern with the Crimes Against Humanity Convention. You would have more chance of accountability being ensured regardless of the ICC status. And of course, there are challenges and risks that might arise if a country is party to a convention. These would apply potentially in all situations. But for the Philippines, there would be some things would need to be considered with a ratification. I mean, one thing is that the Philippine justice system is quite weak. It struggles with case backlogs, weak witness protection, as been mentioned, limited prosecutorial independence in some cases. So this could affect the implementation of a convention. Of course, without strong safeguards, prosecutions could also be selectively used against political opponents rather than being applied fairly across all perpetrators. And there's unfortunately a rich history of that occurring in the Philippines. So we would need to be, it would need to be ensured that it's not used as a political weapon and provide genuine accountability. And of course, investigating and prosecuting crimes against humanity does require specialized training, forensic capacity, areas where Philippines faces shortages. So witness protection and victim support programs require significant resources, and these would all need to be strengthened for the successful application of the convention. So it's, not a walk in the park, even if a country does ratify such a convention. But one would hope that these gaps would be filled in the process. And ultimately, a Crimes Against Humanity Convention would provide a much more robust deterrent against human rights violations to hopefully ensure that the gravity of crimes, such as those in the war on drugs that we saw in the Philippines, never happen again. Thanks for your attention.
Thanks, Rachel, for also demonstrating that crimes against humanity remains one of the tools that we have or will have in the international legal ecosystem. With the Crimes Against Humanity Convention, if adopted, what it offers is also witness protection and reparation provision under draft Article 12. Of course, it leaves the flexibility to states to accommodate those within its national jurisdiction, but it provides that framework both, which is really absent in the current framework that we have. So thank you for that. And I will go back to Yasmin. Yasmin, if you're on call, yeah, I see you. Yasmin Ullah, the executive director of the Rohingya Maìyafuìnor Collaborative Network, will speak to us about the situation in the Myanmar and that of the Rohingya. Over to you, Yasmin.
Thank you so much. Thank you so much for having me today, and good morning, good afternoon, good evening, wherever you are. And thank you so much for inviting me to be part of this panel. Although I'm not legally trained, I will try my best to take a crack at this discussion about crimes against humanity. I'm going to take a little bit of a pivot to focus a little bit more about the issues that are basically the continuation of crimes against humanity or mass atrocities once the community actually leave the place of their persecution. Majority of our work in the network, we are focusing on ASEAN, so a lot of it has to do with dealing with the kind of the bureaucracy, but also the disconnect that there is in the system of ASEAN in general, and we come across a lot of different defects, I would say, that actually basically prevent us from being able to ensure that survivors and victims are actually taken care of. And that's with and without the conventions, the various conventions that countries have, of course, become a party to. Now, it is extremely challenging. Of course, this is not news to any of you. We're focusing on a very, very tragic. I'm so sorry that I'm looking down sometimes because my notes are down here. I have a very different setup today because I'm not home. So my apologies if I'm not looking at the camera. But what I wanted to highlight or contextualize for you today, specifically, I'm going to talk about the Rohingya crisis because I think it is a litmus test for the entirety of the mass atrocity that goes on now inside Burma, Myanmar. But the situation in Burma, Myanmar, especially the persecution of Rohingya in 2017, that the community actually deemed as a genocide, and many others across the globe. Although, in some cases, as I will highlight later on, the connection to the Crimes Against Humanity Convention. Well, since 2017 onward, we've witnessed, some very, very serious systematic targeting of the Rohingya ethnic group by Myanmar's military, security forces, and the power elites. Hundreds of thousands have been displaced. Thousands of lives have been lost. 20,000 was, I think, a conservative number. Many, many different villages have been burned down, hundreds of them to the ground, bulldozed, and then completely erased from the face of the earth. Today, over 1.4 million Rohingya remain in the Cox's Bazar refugee camps with dwindling funds, and many, many, thousands in Indonesia, 200,000 in Malaysia, and about 40,000 in Thailand. And that's just the context of, what's the connection between Myanmar, Bangladesh, and Southeast Asia. So these atrocities, including murder, sexual violence, sexual and gender-based violence, specifically forced displacement, destruction of property, all fit the legal definitions of crimes against humanity under the international law. Despite that, overwhelming evidence, accountability for these process or for these, acts remain quite elusive. And so the challenge that we face in seeking justice for the Rohingya are not just about, legal ramification, but something that's more political and structural. I want to highlight one specific academic. His name is Galtung, and he talks about various different stages or layers of violence. And I really like his definition because we're seeing a lot of that playing out today. What constitutes genocide for him is made up of 3 layers. One is cultural, which is media, propaganda, hate speech. Structure, which is policies and practices, specifically targeting a group of people. And lastly is direct violence, which is the last stage of the manifestation of this genocidal campaign. For the Rohingya, I think these are the simplest explanation that I can find that actually makes the most sense, that describes all stages of violence against Rohingya and basically it helps make it reasonable for us to understand. Now, we are not just seeing that in Myanmar anymore. We're also seeing the replication of this in Southeast Asia. And not just the first stage is done, not just the cultural violence is happening. The structural violence is also taking place. And there are also manifestation of direct violence. So when we talk about crimes against humanity, mass atrocity, or genocide in general, and I'm sorry for being a little bit more broad, all of these are actually manifesting in real life in Southeast Asia in real time. And we have no way of actually prevent, protect, or help the victims in any way, shape, or form, because they are also confined by the national laws. And that's, I think, the flaws of the international system in general, that it does not force, national government to actually do anything unless the government actually commit. And this is the part where we talk about political willingness over and over and over again. But unfortunately, very, very few actually bat an eye or actually listen. So when we talk about crimes against humanity, it's also very, very important to me that, we highlight that crimes against humanity is actually not the be-all and all in the case of the Rohingya. It was actually a creative pathway that the ICC prosecutor office has to take because they don't have jurisdiction over Myanmar, because Myanmar is not a party to the Rome Statute. And therefore, genocide could not be, prosecuted, even though the Genocide Convention, Myanmar is a party to. One of the first, I think, countries that actually signed to become a party to. So it became a creative way for the ICC prosecutor office to actually use as a way to prosecute crimes that took place in Bangladesh instead of Myanmar. And that's the only way that, victims and survivors could actually have any access to justice in terms of the international mechanism. And although, these are very, very interesting pathways and definitely something that's praiseworthy, it does not guarantee, it does not go far enough when it comes to the violence and the crimes that people have suffered. So because now the crimes, instead of genocide, it is prosecuted as crimes against humanity, but specifically forced deportation, there's definitely an effect, and it's less than the enormity of the crimes itself. Although everything kind of, as far as I am aware, the investigative team and various others are still investigating as if they have, full jurisdiction over what happened, but only, investigating because Bangladesh is allowing them that jurisdiction. So crimes against humanity in this case is only a creative pathway, as I mentioned, but also it prevents us from being able to go after the real perpetrator, which is the Myanmar military, who's enjoyed long decades of impunity, both within the country, but also outside, internationally, but specifically in ASEAN. Because ASEAN has played such a significant role in allowing this, on top of that, enabling this, it is almost aloof to the kind of criticism that it gets. And I don't know if the association was conceived on the basis that I don't think that the founders of ASEAN or, the original pioneers of ASEAN foresee that it will become an association that protects genocide perpetrators or mass atrocity, criminals. And that's unfortunately the reality today. So the barriers for victims to actually access justice is no longer just about which convention can we actually push different countries to abide by. It's far more than just one country committing a genocide or committing mass atrocity and us being able to hold that country accountable. It becomes a pattern of behavior that ASEAN nations are actually following suit. It becomes an example for other countries to also follow the footstep. And I think specifically I'm coming to this conclusion because of the misinformation, disinformation, and hate speech being used and being weaponized in this specific sense for political gains, for political votes, to distract us from much larger issues, which is not just state actors, but non-state actors. And we're going into the territory of business and human rights, and whether or not we should expand to hold non-state actors like corporations accountable. I'm not just talking about Facebook. I'm talking about PTT. I'm talking about Petronas. I'm talking about all of the actors, especially Chinese state companies that have actually come in to raise the entire original area that Rohingya used to live on, and expel them. And these are all interconnected in terms of why Rohingya at the root cause are being expelled, or why are the Rohingya being targeted. So I think that the gaps are still there. I'm not saying that crimes against humanity treaty will not be helpful. It will be vastly helpful, because then we don't have to prove this threshold, as previous panelists have already mentioned. But at the same time, I think that states are still protecting each other. We're still not getting to a place where different countries, different states are disengaging with the Myanmar junta, and ASEAN is the culprit in all of this. At best, ASEAN has allowed the Rohingya genocide to prosper or to flourish. At the same time, I think at worst, they are the enablers. They are not the enablers, they are the participants, active participants in this. And in the case of Indonesia specifically, and I will end with this, the election of Prabowo only came about in connection to the Rohingya hate speech rising in Indonesia. And to this day, we still see all of these hate comments on our page every single day. A lot of the same comments are saying, oh, you guys, we have not signed on to the Refugee Convention of 1951, so we don't have a responsibility over any of you. At the same time, because people don't go far enough into the corporate responsibility, or whether or not their national companies are the ones investing to line the pockets of the military junta for them to be able to buy weapons or buy, jet fuel. And all of these are eluding the public consciousness. We're actually not able to put an end to these direct cultural and structural violence that are now manifesting in Southeast Asia against victims and survivors of mass atrocities from Burma, Myanmar. So Prabowo only won because the struggles are seen as separated, and people don't see that Rohingya genocide is now a litmus test to all of our liberation collectively, to all of whether or not we're going to be liberated from these colonial structures that we're all dealing with. And borders are just, one ways that we're being confined. Sorry, I'm going into the tangent, but specifically, I think at the end of the day, the convention will be a great help for the movement or for the access to justice for victims. But something further than that needs to happen, and needs to emerge from a collective solidarity movement, which is seeing all of these struggles as one, not to diminish or undermine each of the struggles or each of the mass atrocities, and how we can go about addressing the root cause, or how we can go about rehabilitating victims. At the same time, I think we need to look at the political willingness. And there is a very specific reason I mentioned this, because I've sat down with so many politicians in the region. The one thing that they keep using was the sentiment online against Rohingya. And this sentiment online that are violence, that are actually now justifying the genocide and mass atrocities against Rohingya, are actually the ones that are going to get these politicians elected. And so the only way they said they're going to get re-elected is for them to actually call for deportation of Rohingya. So now we're seeing re-victimization by the state actors, by the people who should be upholding the law. Even their own national laws they're not trying to abide by. So I'm hoping that the collective solidarity movement will get us to where the pressure will be so vast, the flip side of the coin, where hate speech is no longer there and the pressure for real accountability will be there instead, that we could finally realize the dream of Rohingya being able to go back home and rebuild and all of that. Without that, there's no way. The non-interference clause is just there to prevent people from being able to hold governments accountable. They have no problems actually investing or interfering with each other when it comes to business transactions or economic ties. No problem whatsoever. Investment in this country or that country, no problem. But when it comes to human rights, my God, we are not interfering with each other. So yeah, it's such a lie that we believe, that we're force-fed. So I think going beyond the conventions, going beyond, what international law can allow us. And I think I really agree, and I really hope that, countries are not just going to use these conventions as a way to evade their responsibility or absolve themselves from the responsibilities. I think there's still fear in the frontline countries like Thailand, Malaysia, and Indonesia, even in allowing investigative team to come in to interview victims. That's how bad they're worried about the crimes that they've committed against the refugees and the victims after they've fled. And so I think there's so much more education, so much more awareness, and so much more that we need to instill in the public in order for us to get anywhere at all before we get to even, the treaties or the conventions. Thank you.
Thanks, Yasmin, for this powerful intervention, and I think highlighting and calling out the double standards of states in the region and them shrugging off the responsibility, under international law and even within ASEAN Charter. I think it's also important to realize these are not just theoretical conversations that we are having, but it's an everyday reality of thousands across Myanmar and that of Rohingya in Myanmar and across the region. I would also like to touch upon just a few points reflecting on Yasmin's presentation and connecting it with Crimes Against Humanity draft articles, that especially the conversation about legal responsibility of entities and corporations is also kind of mentioned in the draft articles under Article 6, if I'm not wrong, where there's a provision for legal persons to be held accountable. And we have seen quite diverse positions expressed by member states about their comfortable, whether they're comfortable with that proposition, but that opens up a window for holding entities responsible for their complicity in the commissions of crime. And I think I'll also highlight that Amnesty International and AJC has been raising since many years. One of the demands has been to put an end to the arms transfer, to the end of jet fuel and the military assistance to the military junta, devoid of a Security Council resolution calling for a global arms embargo. ASEAN also has a responsibility as a regional bloc to put an end to this. And we hope that, we'll continue to advocate for it, and we hope that we'll reach a point where we see member states stepping up and, doing what they should do. I think we'll go to some questions first. There's one question, I think, both for Rachel and Yasmin from Michelle, that reads as, would the CAH treaty also have some better safeguards and inclusion for impacted communities? She recalls Yasmin's harrowing stories of having to share room with perpetrators for the Myanmar case. She sends her apologies for the Genocide Convention analogy, but the experience of community should be our yardstick to improve the work. So if you, Rachel and Yasmin, you have reflections on Michelle's question, and then we'll get back to others.
Yeah, I think Yasmin dropped off, but hopefully she'll be able to come back and also answer this question. Otherwise, perhaps another panelist can respond as well. I'm not an expert on the convention, but I do believe, as I sort of mentioned in my presentation, that it does have stronger and better safeguards, more victim-centered provisions that go beyond the Rome Statute. Some more explicit rights for victims and survivors, more provisions on victim participation in proceedings. I think some more provisions on reparations that should be provided to victims. As there's been more evolution on this since the Rome Statute came about. But maybe I'd like to invite maybe Jan, my colleague, to comment on that in a bit more detail.
Thanks, Rachel. Yasmin, do you have initial reflections on Michelle's question?
I think it wasn't the convention itself that actually left a bad taste. I think it's the practitioners of the convention, especially the court, the lawyers, the various personnel that are involved in, making sure that victims have access to justice. I think to this day, and I'm speaking as frankly as I can, in terms of being a representative of a community. I'm not the best one that they have, but I have to do because I'm here. The one thing that we lacked very clearly during the time that I was participating in the ICJ hearing, the provisional measure hearing, was the education piece, the managing expectation piece, but also the fact that procedures in ICC and ICJ are completely different. There are different courts. They're serving different functions. All of those things were not informed very well to the victims that actually arrived from the refugee camps. I happen to have, access because I speak English, and that's a very important skill to be able to actually jump over the barriers that there are. So I had to basically try to do that right then and there, and that was not the best management plan. I think that the legal team, the Gambia's legal team, tried their best, but I think there was also a barrier when it comes to who can accompany the refugees from the refugee camps, because they're seen as some sort of a security threat, which is, when it comes to, as Michelle used the term harrowing, it cannot be more harrowing than victims having to be escorted across, town because people are scared that they're going to somehow run away and seek asylum, as if they don't have that right, as if that's not, what they deserve, to have safety and some kind of, potential protection from states. But of course, because we're bound by, what Bangladesh has to offer when it comes to whether or not we can transport victims to go participate in different places, I don't think that ever people in the camps were ever able to actually travel anywhere overseas, especially to Europe or, part of the West, and participate on an equal ground, because they were never seen as such. And that's what is the most harrowing. Me sharing the room with, genocide enablers or genocide perpetrators, that's a different story. But for them, for the people who have not been prepped properly about how the procedure would go or what they could bring in terms of their participation, it is incredibly disheartening to actually see that. And what's even more harrowing is that, the refugee representatives or the victims representatives are herded around like cattle just because they don't know English. And that, to this day, I'm still angry about it. So, that's that's kind of where I'm going to leave it at. But I think that as a community, as a group of people that are looking for and pushing for accountability and access to justice for victims, we all need to do better. We all need to kind of step away from this, complicated titles and hats that we have, academia or in the legal field, and actually look at victims as humans. Because I don't think that if we were ever put in their shoes, we would even be standing. And that's the reality of everything. I think the patients need to be there a little bit more. We need to apply a lot more empathy, sympathy, and whatever else would help us humanize these group of people, because they're constantly being dehumanized even after they survive these kind of mass atrocities and persecution. So I'll end it there. Thank you so much.
Thanks, Yasmin. And we share your frustration and anger as to how the dehumanization, often intentional dehumanization, leave victims and survivor groups of the conversations that we have in echo chambers, often about international justice and accountability. But if I could ask you another question that has come for you from Chuka. They ask, in light of ASEAN's long-standing principle of non-interference, is there a realistic chance of support for the treaty within the region, or there is no conflict between the treaty and the non-interference principle?
I think we have to be a little bit more delusional than we are currently, because delusion is the way that we can actually get to where we want to be. And no revolution was fought without a healthy dose of delusion, that we can actually get to a better place as a people, as a community. And well, ASEAN has no excuse when it comes to defaulting into non-interference, because it does just fine when it comes to business transaction. It's okay when it comes to interfering with each other's profit. So we can use that as an excuse or as a tactic of advocacy. But at the same time, I think that politicians know that they're a bit of an elite, and people are waking up to the idea that they probably should not have more means than we do, and perhaps they need to be held. They need to be held accountable. They should be on a short leash. They are answerable to the public. But at the same time, because they're utilizing some of these hate speech as a tactic to distract, but also to weaponize to gain more votes, to actually get people very, very riled up and emotional, and focusing on the wrong thing, which is hating on refugees, even though refugees don't actually. We take very little when it comes to the GDP or whatever gross income that the country makes. Barely any of the countries in Southeast Asia actually takes care of Rohingya fully 100%. I think more than 80% of the funding comes from INGOs, and that's not the reality that people actually understand or are aware of. And even that, they're utilizing some of these languages in order to basically twist the truth, to show that refugees are actually burden to their societies, so that they can gain more votes by, going against us and actually become the protector of the country. So I think twisting things around and trying to, fight some of these disinformation, misinformation, and hate speech will be the important key tactic in order to overturn some of these non-interference clause. Because guess what? When the protests break out, like it did in Indonesia, and when politicians are pressured by the opposite of hate speech against Rohingya, they will have to abide by, the rules that people come up with. And that's why the collective solidarity is going to be the monumental change that we need in the region. We're doing it at APF, which is wonderful. It's such a friendly space, but I think it needs to be mainstreamed. It needs to be talked about a lot more. And I think it becomes a touchy subject for some reason in Southeast Asia. And I've been told by so many partners, and very, very understandably, that some of the policies are better off, improving if we stay silent about it. And I understand where they're coming from, but at the same time, I think the movement to liberate all of us, and especially, to hold each other accountable, especially to hold genocide and mass atrocity architects accountable, it needs to be a loud movement. It cannot be hidden away.
Thank you for that, Yasmin. Thank you for your powerful comments. And I think, a bit of a reality check as well, right? Like we're trying to bridge this gap between the legalese, the legal environment, but the reality on the ground, the geopolitics, and honestly, to center the needs of victim and survivor communities. So I think your comments are going to be particularly helpful also for the framers and the negotiators of this treaty to ensure that these are taken into account and placed center stage. And not forgotten, as was done in sort of previous iterations of previous treaties. I think what we'll do now is, and I think, thank you, Rachel and Yasmin, you all have opened up the door really to ASEAN and the region, and what are the regional sort of complexities as well within these countries, but how it works across the region. And I think what we will do now is Akash will actually introduce us to what states in the region are doing and what they've been saying quite explicitly linked to the CH treaty. So really, we've got their statements on record, we've seen their positions, and as I'd said before, Akash is the expert on sort of monitoring and tracking and knowing what states are saying. But I think more for sort of forward-looking future negotiations as well, what we as civil society should be saying that states need to be doing differently, and what we should be articulating as our positions and the lessons that we've learned from, what's been happening so far. So I think with that, Akash, we'll turn to you just to also say we have a few other really good questions that we will come to once Akash has made his presentation. So Akash, all yours.
Thanks, Priya. Yeah, I think you can see the visual of the mapping that we did after last year's October 6th committee session, just focusing on the position of Asian states. So the AJC and others have been mapping and monitoring the position of states at the UNGA over the past few years. For AJC, our focus has been the position of Asian states, while a few states did not participate in the UNGA 6th committee due to lack of capacity and other reasons. Asian states have engaged actively with the draft articles as compared to other treaties. Since 2019, we have also seen a growing support within the Asian bloc, including ASEAN states, for the draft articles and a future convention. If I could go back to, or just highlight the 2023 and 2024 resume sessions, these were two innovative sessions which were created within the 6th committee to discuss substantive, provisions of the draft articles, and also the subsequent October 2024 session, of which you see the graphic on the screen. An increased number of states and region groups participated, reflecting perhaps the greater engagement and also absorption of the text by the delegations. As Jan mentioned, the 79th UNGA, the General Assembly session, saw over 99 states co-sponsoring a resolution calling upon the General Assembly to convene a diplomatic conference for the CAH convention. And that included a number of ASEAN states. And if you start from the top, you will see Afghanistan and Myanmar, from Asia, calling for draft articles to move to negotiation stage, especially highlighting or basing their, arguments centering the victims of mass atrocities by reaffirming their commitment to human rights and accountability, especially given the situation that we are seeing under the present regime, Taliban and Maìyafuìnor. Just a small caveat that when I speak about both these countries, Afghanistan and Myanmar, and position in the Sixth Committee, these are the positions expressed by the permanent representative appointed by the former civilian governments and not by those who are, exercising control over these territories right now. If I go to Thailand next, we have seen Thailand move from fairly, hesitant state to take or support the convention or the draft articles to, in October, expressing its support for adoption of draft articles into a convention. If I can quote, according to Thailand, such a convention will present a mechanism through which states can strengthen their domestic laws, national adjudication, and international cooperation to ensure accountability for crimes against humanity, unquote. I think with Thailand, centering and calling upon states in the region to have, look at the provisions of the Crimes Against Humanity Convention, facilitating more interstate cooperation on horizontal level. And I think that's essentially one of the strongest points of this convention, mirroring Genocide Convention. We see that Crimes Against Humanity Convention offers the same. It has really extensive provisions, Article 13 and 14 on extradition and on mutual legal assistance to ensure that states cooperate with each other to put to end the impunity for crimes against humanity. Similarly, we see Indonesia, centering or calling upon states to, move for diplomatic negotiations, especially because it is not just a tool for prevention and punishment, but also a tool for promoting cooperations between states and harmonization of national laws. Of course, Indonesia, in its 2024 Penal Code, criminalizes crimes against humanity, and therefore it acknowledges the normative gap that is there in international law, and which will be filled by a future convention. So both Thailand and Indonesia have been centering their arguments, about facilitating interstate cooperation. This is not to say that they don't have their textual concerns with the language of certain provision, but they have shown their willingness to move to negotiation and hash out the final text. I would also, talk about Malaysia. It's that we talk about Malaysia, especially at this point, being the chair of ASEAN. But Malaysia was also one of the co-facilitators for discussions in 2023 and 2024 on crimes against humanity. So they navigated the discussions among member states in the resumed sessions on the draft articles. And, I think connecting back to Michelle's point on the general support that we have seen from Global South states, especially Malaysia in regards to the mass atrocities that are being committed in Gaza. And Malaysia has been a strong, vocal supporter for accountability for mass atrocities in that regard, and has been calling for adherence to the Genocide Convention. Malaysia, also being the member of the Hague Group, has been calling very strongly states to uphold the principles under the UN Charter and the principles under the Geneva Conventions. So I think Malaysia has shown its support for the draft articles, and we hope to build, support to Malaysia, not just for the situation in Myanmar as one of the potential champions for Rohingya and accountability in Myanmar, but also as one of the champion states that could perhaps lead or organize Asian states in the crimes against humanity negotiations. Next, I think I'll go to the Philippines. You see Philippines is in the light green. Again, Philippines, the next ASEAN chair, has been supportive of the draft articles, and based on its own 2009 domestic law, which criminalizes crimes against humanity, has been supportive and has been focusing on, or has been highlighting the dual nature or dual scope of the convention, which is both prevention and punishment of crimes against humanity. And I think this is a common thread amongst the ASEAN and Asian states, that they have been highlighting the prevention obligations that flow from this convention, much like the Genocide Convention. And we have seen that in Bangladesh, we have seen that with also Indonesia, highlighting the importance of prevention obligations, and that to be strengthened even further in the draft articles language. So the Philippines have also called, for national jurisdictions to be enabled through this convention to effectively prosecute, investigate and prosecute perpetrators, and not to let them go scot-free. And just to highlight that this decision has been in place even before the government's current government's position on Duterte and transferring him to the ICC. In yellow, in the regional bloc, you will see Singapore. Singapore in yellow means it has all these years have been neutral through the deliberations of Sixth Committee. Singapore has maintained its neutrality, much like previous treaties it has, or human rights treaties, and it sees the value in having an international convention on crimes against humanity, and it recognizes a normative gap in international law. But it has some existing concerns with the existing text. For example, while the text do not allow or do not specify any hierarchy about prioritization on jurisdiction, Singapore has a strong opposition to or perhaps Singapore wants the territorial jurisdictions to, triumph over any other jurisdiction, which Jan also mentioned that Article 7 facilitates, when read with Article 10, universal jurisdiction. So we see Singapore having an opposition to it, but Singapore has been an active commentator and, engager with this process all through. It is one of the states which has also submitted a written comment back in 2023 when the UN called upon states to submit states' position on the draft articles. One of the, again, strong supporters in the region and, not an ASEAN member for now, but hopefully soon, is Timor-Leste. Jan also mentioned, and Priya also mentioned Timor-Leste, history with UN East Timor Tribunal in Delhi, and, its history with adjudication upon crimes against humanity prior to its independence. So East Timor-Leste has been one of the strongest, proponent of the strongest proponent of the convention. It joined the Portuguese language speaking group last year to express its sentiment that it is calling upon states to move to negotiations and hash out any differences, or review and strengthen the language, whatever that differences may be, once we reach the negotiations. So we strongly appreciate the role that Timor-Leste has played in also pulling together all the Portuguese nations group, and we hope that going forward, Timor-Leste, once it joins ASEAN, will be able to rally support within the regional bloc, to support the Crimes Against Humanity Convention. Lastly, one of the states in red you will see is Vietnam. Vietnam joined a handful of states expressing their reservations, against the utility of the convention. In a sense, Vietnam was calling for more detailed study and deliberation about the draft articles, and not to push the draft articles to the negotiations as such. Having said that, it is important to note that all the support and the opposition to draft articles, we should overlook that position as of now, because as a matter of fact, we are moving towards diplomatic negotiations. the December resolutions by General Assembly, strongly calls for a treaty to be adopted by the end of 2029. So we hope to build on and work with the states who have expressed their positive support and ensure that they continue to do so in the years to come. But just to highlight those states in gray, as per my notes are concerned, we have not seen Brunei, Laos, and Cambodia participate in the sixth committee discussions. But that could be, again, because of capacity or otherwise. But we hope that we'll be able to engage with them going forward and have them on the green side from the gray. So I think I'll stop there and happy to answer questions.
Thank you for that, Akash. That was really a tour de force, and I think it's really interesting and important to know what these positions have been, and then to see if there are, again, with geopolitical changes, added advocacy, more pressures, whether these can shift into green and lighter green, from the yellows and the reds. I think there's one question that's particularly relevant for you. This is from Kate from the ICJ. And I know you've touched upon it, but I think a little bit more detail, perhaps. So Kate asks, what are the differing state positions on developing a CAH convention? What are the barriers to supporting its development and enactment as expressed by states, apart from the sovereignty argument? And you've alluded to this a little bit, but which are the states that might be the regional champions of a convention that individuals and organizations can support to bring others along? So I think perhaps maybe some of those distinctions between even the green and the light greens, right? On what basis are these states expressing their support, or the ones that are that at least in the sixth committee have said they don't want this to move forward? What's really the reasoning or the basis? I think a little elaboration on that would be really helpful.
Thanks, Priya, and thanks, Kate. Thank you for joining. Today, Kate and ICJ has been a strong supporter. AGC has been AGC member and has been working for many years at looking at the Crimes Against Humanity conventions themselves. Kate, I think to just answer briefly, all the states that we have put in green that I just highlighted, they haven't had any problems with moving the text forward. All of them had only concerns with certain provisions as to how it was drafted, and what it implied in the commentaries that we have also shared on the text. But it was largely India, Vietnam, Russia, China, and a couple of more that had more strong oppositions of not going and moving towards negotiations. So I think barring those states, we have not had issues with states moving the draft articles to negotiations. And as far as the champions are concerned, we think and we hope that we will be able to work with Philippines, Malaysia, and Indonesia, because we have seen, including Thailand, that just hold on to their statements that they have made previously at the sixth committee, and continue to make them see the value in the convention, and tie it up with ASEAN principles as well. And with Philippines being the next chair, and the positive statement and positions that they have expressed on draft articles, we hope that with Malaysia's chairmanship now and next with Philippines, we'll be able to continue putting pressure on ASEAN states to lead from the front for the region at least. South Asia, as I mentioned, has not been that proactive and supportive of the draft articles. But yeah, we hope that Southeast Asia and East Asia, with Japan, South Korea, being an active supporters, to take the lead and move, or bring the Asian perspectives on the table. I think I'll end there, but just to, highlight maybe another question and put it for Jan and you, or whoever on the panel wants to take it, is from Kanti, Tapas Kanti. He asked, do you think CH conventions will be a reality without political willingness of the current political parties in ASEAN and rest of Asia? You can take into consideration the current culture of countries to denounce their membership of the ICC. Jan, would you like to take that?
Yeah, I'll just try to be brief. And this also goes to a question by Chuka about the sort of realities. Now, yes, the realities in terms of ASEAN states, but the reality also is this convention will come. The UN resolution says there will now be a conference, and at the end, there will be a convention. Now, what is in the convention, that's open, but a convention will come. Therefore, all states, including ASEAN states, have a decision to make. They can participate in the negotiations or not. But if they don't participate in the negotiations, then I don't think they can reasonably claim that whatever the outcome is Western, neo-colonial, pushing some strange alien foreign format onto them. They have the chance to participate in shaping international law. Priya earlier mentioned the experience of the special chambers for Cambodia and special chambers for East Timor-Leste, apologies. This is where Asia, Southeast Asia, contributed to the shaping of international law. This is one such chance, and the states need to decide if they want to be part of it or if they want to be outside the room. The same as once the convention is in place. Now, a crucial point to keep in mind is the state, the home state of the alleged perpetrator, does not need to be a member of that convention for the convention to be carried out or to be implemented and prosecutions to take place. So let's just say in the future, a Burmese general, and Burma will not be part of this for the time being, Burma general will, under the convention, if we had this convention in, let's say, 5-6 years, would be arrested in Germany. Now, if Myanmar is part of this, then they have the rights to make sure their national is protected. They have the right to be consulted. They have the right to say, we want to prosecute, extradite them to us, because they are part of the club. Or they're not a member, not part of the club, and then they have no rights, and then likely at least an investigation and possibly a prosecution would take place in a state like Germany. So again, states really need to decide, do they want to be part of it or do they not want to be part of it? And the final example here, again, for the negotiations, Chuka specifically, the African states right now are actually showing a good example. They have recognized that this is a potential opening for them to have their interests reflected. For example, in adopting and adding the crime against humanity of slave trade, which is very important for many African states. So the African states have started to organize themselves, to do joint statements, to have internal coordination. They don't have agreement on everything, but they have seen that there's a chance to protect their interests. So, and part of the realistic, the realism we've talked about before, which often has a negative connotation, part of this realism also is that it is actually in the self-interest of many of these states to at least be part of the negotiations and also to actually to be part of a final convention. Thank you.
Thanks, Jan. Just checking, Priya, if you have anything to add.
I think, if I may, just one final point, which is, and drawing from our experience also being part of the negotiations for the Mutual Legal Treaty, the Ljubljana, the Hague Convention. I mean, I think the one point to really flag there is that positions do shift, and, your usual suspects, it would be, you can't necessarily always rely on them. So essentially to have a wider swathe of support, whether it's small island states, whether it's other states that have a specific interest in CAH, whether through environmental degradation or, put a particular lens that they are interested in this treaty, and that sort of engages them more. So I think that's important. And I think the other important thing, and we've talked about this right at the beginning, is engagement, CSO engagement, civil society engagement. And I think what we're trying to do is sort of raise awareness among the wider civil society cohort and contingent across ASEAN and South and Southeast Asia But of course, I think we need more of a groundswell of support as well. So we need greater dissemination. And on that note, I know Akash will point this out to you. There are a lot of Q&As. There's a lot of basic work that we've done over the last 3, 4, 5 years, all of us, all the partners on this call. So you can repurpose and reuse some of that and make use of what already has been done beforehand. So I'll just stop with that, but just to say that we need more participation and more engagement in this process.
Thanks, Priya. Just checking if we have any last questions from anyone, or anyone want to share their thoughts. If not, I think we can move to the closing. We are just 2 minutes away from the time. But thank you everyone for sharing your insights and comments with us. I would have loved for us to continue the conversation, but we are mindful of the time. So I'll just highlight the few things that we have heard today during the call and reiterate as we move forward with the CAH process that we need more engagement from Asia. As Priya highlighted, we have seen less of that in the previous diplomatic conferences. And as Jan mentioned, that this is such an opportunity for Asian states and Asian CSOs to center its voices and concerns. And if we do not take advantage of this platform, then I think, it will be a miss from our end. So if you are in talks with Ministry of Foreign Affairs, Ministry of Justice, or the New York missions of your countries, I think it is crucial to demand as wide as CSO participation as possible in all parts of the diplomatic conference, including for non-ECOSOC civil society organizations. As Jan mentioned, many of the Asian NGOs who would like to participate do not have ECOSOC registration, and therefore it's crucial that we have full, effective, and meaningful participation of civil society, organizations and human rights defenders and victims and survivor groups in all the processes that will take place starting next year with the PrepCom and leading up to the diplomatic negotiations. Second, Asian states and regional groups have been called upon by the General Assembly resolution to hold substantive workshops on the draft articles. Such a workshop or discussion would enable all of us as stakeholders to table our concerns and recommendation to strengthen the draft articles. We have seen questions from Faustina about reproductive violence, and also, comments from Rachel and Yasmin about victims and survivor groups, witness protection. So these are opportunities for CSOs and all of us to table recommendations and proposals ahead, of the PrepCom and also in the run-up to the diplomatic conferences. So calling upon states, ASEAN states would be effective, and we can ask them to hold a regional workshop, and put forward our considerations. Finally, if you would like to continue the conversations, co-organize, brainstorm about the convention and its role in Asia, please feel free to reach out to us. My email address is mentioned in the email sent yesterday. You have also received a link to the feedback form in the chat. Fill it out and we'll be happy to be in touch. And thank you so much for being present here today. It was lovely to hear your thoughts, and we would like to continue our conversations on CAH as we go forward. Thank you, everyone. Have a good day.